We are ready for the second case, which is 128248, State of Kansas versus Logan Benjamin Gentry. Whenever you're ready, counsel.
You want us to announce or just go right ahead?
Go right ahead.
All right. I'm going to get back in the game after, I feel like this is the second time this has happened recently. Last time I was here, I had to learn about the difference between adjourning a county commission meeting and a recess. So now I'm learning about, anyway. May it please the court.
You're happy with your career choice. That's what I'm here.
Well, my case this afternoon reminded me why I was a criminal lawyer and not a civil lawyer, because I felt like it was discovery in a civil case that I had to go through in that one. In any event, may it please the court, Patrick Dunn, Deputy Appellate Defender, here today on Logan Gentry, on behalf of Logan Gentry. May I please have 3 minutes for rebuttal, though today I hope to apply Judge Perrin's old rule of you don't have to use your time and will not be penalized if you don't. As he used to say. This is a pretty unusual case in as much as I think we all notice that there was a bit of a problem below. Pretty quick timeline, just to recap. I'm sure you're aware of the facts, because this is a short case. April 10th, client's arrested, Mr. Gentry's arrested. June 10th, Logan enters his plea. August 12th, sentencing hearing. District Court finds him to be a G, imposes 24 months probation with the underlying prison sentences, 31 months. Explicitly tells him probation begins that day and he will be released, and then the court will be in recess. Now, earlier in the hearing, the state had said, hey, we haven't got all our receipts and documents and whatnot for restitution. Can we hold this over? The district court never actually said yes. The district court just said, hey, did you guys actually agree? I thought it was in the plea agreement you were going to agree on restitution. And everyone said, yeah.
Well, wasn't it, I mean, at this point, because the victim was still hospitalized.
Correct.
With significant injuries.
Yes.
And I believe the court actually says, more or less, if we were to impose everything, it's going to be unworkable. So you all figure it out and come back to me in 2 months, 60 days.
Well, the state had asked for it. Now, the state was the one that brought up delaying it 2 years.
Well, but it's in the plea agreement. He knew.
Sure. No, I'm not disputing that. I'm just saying what actually happened. No date was actually set until after the court had said, and I think that's important, that we're in recess. And then the state says, oh, wait, can we get a date? And that is on page 4 is when the state initially broached it. And then I think it was page 16 to 17 in that area of the sentencing hearing where the district court said we're in recess. And then it was brought up by the state, oh, hey, can we get a restitution date? So I think that's important. I don't think that's the only defining factor here, but what I think is important is what happened. And the district court says, you're going to be released today. I want you to go over to Chase County. And I believe it's normal for them to send people over to Lyon County, over in Emporia, just down the road, down Highway 50, to take care of everything there. And he says, you're going to go over to the Lyon County Courthouse, go to community corrections, and get started. And that's actually what happened. He got started on probation, was doing probation, and as is the case all too frequently, unfortunately, with people with drug issues, little over 2 weeks later, we have an affidavit of probation violations. August 30th. September 23rd, the district court actually revokes that probation and imposes the underlying prison sentence. And then we have October 15th, the actual restitution hearing is held with the $85,000 in restitution.
But there was no question that, in fact, the court ordered restitution at sentencing. The only issue was the amount. But restitution was, in fact, ordered at the original sentencing.
Correct. Now, the problem, though, with that is if we step back for a second, well, first of all, I guess I just want to point out, we only have 3 things we're really dealing with here. We know restitution is part of sentence, that's a rule. We know the rule, restitution is supposed to be imposed before sentence is imposed. And I'm gonna be honest, I told the Supreme Court in McDaniel, you need to just delay sentencing out, quit doing this. Oh, we're gonna bifurcate, do all this. It's gotta just do it all at once, it'll solve the problem. They didn't listen to me, and now you have problems like this. Because I get it, jails don't wanna pay for people that are gonna be on probation. It's a relatively short sentence. They know he's presumptive probation, you want him out. But the final thing we have is the rule that goes back quite some time, ever since the guidelines were put into effect, that once sentence is imposed, it can't be modified. So, was sentence imposed is the real question here.
But it wasn't modified. Even if it was imposed, it wasn't modified.
It was by adding an amount to it. There was no amount. There was $0 ordered.
The sentence is restitution. Was restitution ordered? And it was. That wasn't changed, it was completed.
The problem is, to do that, he shouldn't have put him on probation. And I point this out in my brief. There's a mechanism to handle this. And I would urge the court to go ahead and point that out as some guidance to the district courts. If you want to do this, what you do is you put someone on bond. And you can put them out on an OR bond. And as I pointed out, there's repercussions if you mess up that bond. It's not a get out of jail free. It's even worse. You now have consecutive sentences. You change the presumption from, in probation cases, flips to presumptive prison. There's all kinds of consequences. That's the right way to do it.
Okay,
But if you put someone out and put them on, actually on, and start their sentence, the sentence is final at that point.
What is the authority that says the court could not do what it did?
The fact that the sentence happened. It's, again, I would go back to McDaniel saying, the plain language of 2234-24D says restitution must be imposed before sentence is imposed. That's what the statute says. I don't know why they had to jump through and contort. In federal court, they do this. They have provisions to resolve this. But you just follow the statute. This never happens. It's never a problem.
Well, but it happened in Hall, which at 45 Canap 2nd 290, it happened there. And it happened in Cooper with a very similar situation in Cooper where they were on probation for 6 months before the restitution amount was set. So it does happen. And it wasn't dinged then. So how is this case any different?
They weren't revoked, I believe, in those other cases.
Okay, but
which matters.
No, but you're starting at the beginning and saying he couldn't even do that.
I think those cases are wrong, but I realize you're bound by them.
Okay, so shouldn't
But
you
I'm
be
saying
bound by them?
this is different.
It's only different because he was revoked.
I know.
But that's not what you're complaining about. You're saying back here the court couldn't do what it did. And now, because Cooper said it's okay, you're saying, well, this is different. But it's not different. It's the exact same thing. It just went further in Cooper.
I guess we disagree on that, and I'm not going to change your mind on that, and I'm not going to waste my time trying to, because we have a fundamental disagreement there. However, I would point out that there are many probation cases that go on out and they say, yeah, we'll figure restitution later, and then there is no restitution ever figured. So in those cases, the defendant obviously goes on their probation, completes their probation, and they're done. Under the state's theory and under what you're saying, those people never started their sentence at all. It never happened because they never resolved this restitution issue. And that can't be the case. There's not hundreds or if not thousands of people across the state of Kansas that actually never did their sentence. It's passed 5, 10, 15, 20 years ago. They're not still out there not having been sentenced yet.
So what happens to the person who's on probation and restitution's been ordered as you say that it should, it's been ordered, the amount's issued, he goes along on probation, loses his job. Now all of a sudden it's unworkable. And that amount is no longer going to be something that he can manage. So he files a motion to modify the restitution amount. Do we pull him back off of probation? What do we do then? Because there's no restitution amount.
The amount of restitution, let me back up. No, we've made this determination just by putting it in there that it's not workable. Now, you can modify the conditions of probation as to the amount that you pay, because restitution, I mean, let's be real here. He's never going to pay, Mr. Gentry's never going to pay $86,000 in this case, most likely. At the time he was revoked here, he's 20 years old. His employment prospects are gloomy at best. He couldn't finish HVAC school. His jobs were DoorDash and Arby's or something to that effect. This isn't someone that's going to be able to come up with this. The reality of what's going to happen, which happens in many, many restitutions all over, is set an amount that is possible for them to pay a month. This is the reality. We've all seen this stuff. I've had cases where it's hundreds of thousands of dollars, and the judges flat out say, this is ridiculous that we're ordering this, but I'm going to order it, so they are making some payments along the way. And it used to be they did that because it automatically converted into a civil judgment. That no longer being the case, be that as it may. We're not so back to your hypothetical, they're not asking to modify the total amount of restitution. They're asking to modify the amount they have to pay every month. That's what's happening there. It's not modifying the restitution, total amount of restitution. Because the reality is you only get X amount of time. Now, I have all kinds of gripes about how they can continually extend probation and keep someone on probation for non-payment of restitution, because I think it's a terrible waste of state resources, but I'm not in the legislature and it's not my place to do that. But the point is, the restitution is not going to be modified in the future. It's the amount of the monthly payment that's modified. That's a nice long-winded answer for you. So, again, in my brief, I pointed out what the appropriate method is, and based upon the reality of what happened in this case, sentencing was final on that date. Now, obviously, there is the alternative issue here, which it sounds like Judge Isherwood is looking at, is that if the restitution order was valid, then you weren't on probation yet, because you don't start your sentence until it's final. So under those circumstances, I guess the appropriate remedy is to go back and place him back to where he begins his probation. Now, the state in its brief says, oh, you should just vacate the sentence altogether and you get to start all over again. And you can consider the fact that he messed up his probation when you're deciding to put him on probation. Now, the problem with that is the state's wrong. The state cites to Warren for that, saying you're able to do that. But Warren was a case involving the failure of a district court to understand it had discretion to consider a departure factor, which has nothing to do with this case. The case that does matter is a case they cited in the first issue, State v. Gooder, which is Gooder, Morningstar, those cases. Warren's one of them, which a couple of these were my cases along the way too, where the court said, if a portion of a sentence is incorrect, you don't get to change the whole sentence. You only get to change the illegal part. Now, there's nothing illegal about placing him on probation. He was presumptive probation in this case. There was no departure. He was appropriately placed on probation. That's not an illegal sentence. Therefore, the remedy is not to wipe the slate and start over completely and punish him for his probation violation and get to the same place we are now. That's not what you get to do. You have to go back and put him on probation.
How do you address the violation in that sense?
He just gets a pass?
Yeah, because they messed it up. They should, if he was on bond, then they would have had a remedy. If they'd done it correctly and placed him on bond, that was the case. But no one said, we're putting you on an OR bond. Or we're lowering. Mr. Gentry apparently had no funds available. It started off with a pretty high bond in the beginning. It got lowered again at sentencing. At the plea hearing down to, I think they got it down to like $2,500 cash surety, the rest OR. And he couldn't even make that. He just did not have any funds available. But I mean, it's clear, he was not put on bond at sentencing. He was put on probation. So either he was on probation and his sentence was done and there is no restitution, that's your one choice, or the other choice is restitution's fine, he wasn't on probation yet, he starts on probation. And that's what the court has to decide today. So if there's no further questions, I think we've beaten the horse completely dead.
Further questions?
Thank you.
Good morning, may it please the court. Tyler Winslow, Assistant Solicitor General, appearing on behalf of the state of Kansas. My basic start here, I guess, is to affirm the restitution order and remand resentencing, remand for resentencing, relying on the same principles as the appellant here. Sentence wasn't final until the restitution order was announced, because that was about 60 days after the initial, I'll use probation as the term because that's what the district court used, quote unquote starting, and then the revocation having to happen about a month after that and a month before the restitution order. The revocation order just can't be given effect. That's the state's reading of Hall and Johnson and that progeny of cases.
But all those cases say is that the restitution has to be complete. There's nothing that says he can't be put on probation and probation revoked when only the amount remains. The restitution has been ordered.
Yes, Your Honor, and I guess the way I'm reading Hall is that the court to do this really to retain the jurisdiction to actually set an amount. The court has to do, I think Johnson gives us that more than nothing language.
Which the court did here.
Which the court did, and I guess the state is reading those two cases together saying both of those things have to happen finally for the sentence to be quote unquote a final order to set the timelines for appeals and that type of thing.
So even though that language is not in Hall or Johnson or any of the cases that either party cited that says it has to be complete, we are just supposed to extrapolate from impose the amount, even though it's been ordered, that the court couldn't do what it did here. Even though there are other cases out there where this exact same thing has happened, somehow we read the tea leaves that, sorry, district court, only bond was available.
It's the revocation order, I guess, is where I'm getting hung up with, Your Honor. And it's that revocation order that, because I understand, and I understand the court's position here, particularly with the fact that the district court's trying to give Gentry the benefit of starting probation immediately. It is not lost on the state that he gets to start probation, and if he's successful on probation, this issue never comes up. If he's successful even for the 60 days and gets to the restitution hearing, the issue never even arises under Hall, Johnson, and progeny.
Well, why would we even give him credit for probation? If we can't revoke him, why, how can we give him credit? I mean, isn't what's good for the goose good for the gander?
It just wouldn't be, I guess there wouldn't be an issue for the court to review, because I don't think the state would be able to raise the issue, and I don't think Gentry would raise that issue.
Well, regardless, regardless if it flies under the radar, doesn't make it okay.
I understand the position there. It's just the state's, the way the state reads Hall and Johnson as the controlling cases here for the probation order itself and how we respond to the revocation of probation. And again, the state's understanding of the facts here is very distinct from other cases because we have a presumptive probation case that really just changed the nature at sentencing, I think.
So when we have the logistical problem that we have here where we've got an amount of restitution that may be, the determination is a little bit lingering because we're dealing with health issues and medical bills and kind of gathering all of that information. If we don't put the defendant on probation and he can't afford to bond out, or even if he can, all of that time that is spent figuring out the amount of restitution, there's no way for that defendant to get credit on his or her ultimate sentence for that time while they're waiting for those logistics to be sorted out. Am I correct?
If they're on
presumptive probation.
If they're on bond, yeah, yes, because they should be on. If they're going to be released, they should be bonded out. They could do an OR bond.
But if they can't afford to get bonded out and they don't get an OR bond, they're just sitting there in jail, and there's no credit towards the probation sentence when it's eventually issued. Correct?
Yes, sir. If they
So
get a probation.
what are we to do in those situations when you have you get to the sentencing hearing and you logistically can't figure out yet the amount of restitution, what is that defendant supposed to do?
If they're presumptive probation, because the issue resolves itself if it's a presumptive prison case. Or if
Right,
they
but we have
live
lots
in
of
a cop.
presumptive probation cases. What do we do in that case? How do we help that defendant? How do we get them started on their time or give them credit if we don't start the sentence at that time and then figure out the amount later, but at least get them started on some credit towards that probationary sentence?
There's just no credit. I think it has to be bond, and it's really, I think, analogous to plea hearings, where at the plea hearing we were guesstimating based on our initial perceptions of criminal history, this case is going to be presumptive probation. And then the district court says, you pled presumptive probation, we think,
So then
go out on bond.
the only olive branch you're offering them is at some point you're going to be sentenced. You're out on bond, but you're going to have this hanging over your head. And you can't get started on your sentence. You can't get any kind of closure until this amount is figured out.
Well, that's why, I think that's what Hall was getting at. I think that's what the Kansas Supreme Court was getting at with Hall, is we don't want to hold this indefinite restitution case, particularly in a case like here where the facts are pretty egregious. We come to a quick plea agreement, which is, I think everyone can agree that's a good resolution to a case like this. But we don't want to have this indefinite suspended restitution amount that's prolonged and protracted while we get all this stuff. And that's why I think the sentence becomes final with the restitution order. That's really, I think, why Hall reads the way that it does, and that's what the state's is.
How can the defendant enforce the rights you say Hall gives them to have that restitution amount quantified? I mean, aren't they kind of at the mercy of the state and whoever's figuring out the amount? How can the defendant enforce that right and say, hey, I want to get started, get this number figured out?
Well, that's
What's available to the defendant to achieve that closure?
exactly what happened in this case. Judge, we'd ask for a certain amount of time to set the restitution hearing. And then with the defendant and the defense attorney in the room sets a date. Judge, I want a faster date.
So the defendant would have to object at that point and say, no, you need to get this figured out in 30 days and not 60 days.
Yes, Your Honor.
But isn't there a distinction between the issue of restitution itself, like the judge saying, I am ordering restitution, period, and the amount of restitution? I mean, if the judge says, I'm ordering restitution, period, isn't the issue of restitution then concluded and we're only talking about an amount? Is there a case that says the issue and the amount of restitution must be set before sentencing is final?
I think that's in Hall. I cited it in my brief at page 3 as Hall 298 can at 986. Is the authority I have to say that we need both an amount and the order. And that's why the state conceded the probation revocation has to be remanded.
So then that takes me to the next point. What does this look like when we send it back? Counsel says that he should just get a pass on committing his new crime.
No, Your Honor. I think that the district court thought he had properly ordered probation, and so at the revocation, or not at the revocation hearing, at the restitution hearing, had the defendant been on bond, the district court could still consider that conduct at sentencing, particularly in a restitution case like this, or in the same manner, a district court shouldn't be required to turn a blind eye to a defendant's conduct by passage of time between a plea agreement and a sentencing, or a plea hearing and a sentencing hearing, or in this case, in between the initial sentencing and the restitution hearing. That's why the state's asking under Warren to allow a remand for the court to reconsider that and decide whether or not the district court ordered the right sentence in light of the conduct.
But in a plea hearing situation, that's already accounted for, where they're not going to be held to their plea recommendation. The state's not going to be held to their plea recommendation if he doesn't behave in the interim. We don't have that here. So you're just saying they just go back and begin anew.
I guess I don't understand what the court.
In a plea hearing, when they enter their plea, there's an agreement between the parties as what their sentencing recommendation is going to be. But only if criminal history remains the same, the defendant behaves, all the things, by the time sentencing comes. If he doesn't behave, if he does commit a new crime, like Mr. Gentry did here, that's accounted for, and the state will say, we are not held to our obligation to make this sentencing recommendation if he commits a new crime. So that's a totally different story, because that contingency has already been planned for. We don't have that here. So what's the authority that says just go back and begin anew?
The only authority I have is Warren, and it's just that the district court.
So then
should-
why, and I'm sorry to talk over you, but I just want to make sure I get my question out. So Mr. Dunn says Warren doesn't apply. How do you respond to his contention that Warren's inapplicable?
Just the very facts of this case, because it's a factually unique case, I don't think any other cases would preclude analogy to Warren, because the district court was trying, in I guess the fundamental fairness aspect of this, the district court's trying to let Gentry start probation. He's trying to get a jump on this, let him get out of jail and start building his life back up, and he just wasn't successful. So it seems to the state that the district court should be allowed to consider that anew. Pending further questions, I stand on the brief and ask this court to affirm the restitution order and remand for resents.
Any further questions? Thank you, counsel.
Okay, kind of going way back, Judge Klein, you said, well, you had a problem with, or questions about a defendant not getting, how is he supposed to get time credit? Well, the reality is, in a presumptive probation case, you don't. You sit in jail the whole time from the time you're charged all the way to sentencing. You don't get that time in a probation case. It's just tough luck. In a presumptive prison case, you do. You get jail credit. And that's the difference here. So, yeah, unfortunately for him, the only mechanism for the district court to do what they did was, as the state pointed out and I pointed out, is put him on bond. And again, here, there is no pass, as some of the other panel members have said, for this potential new crime. You get prosecuted for this new crime. How's that a pass if you get prosecuted for a new crime?
Because it should impact the case that he's on probation for. That is, in fact, a pass, Mr. Dunn.
If he's on probation.
If he is, in fact, on probation and he's not held accountable for the new crime that he would otherwise be held accountable for, then yes, that is, in fact, a pass.
Well, it's not, though, because under Your Honor's rationale, it doesn't matter if he gets prosecuted at all. You're saying he should get double bonus things. He should be on probation when he's not on probation and be subject to the terms of probation and start his sentence when his sentence hasn't started. Because I think I need to clarify with Hall, and I think what the state was mentioning also, sentence is either final or it's not. And that matters for a big reason, and that the notice of appeal can't be filed until after sentence is final.
So how do you deal with the piecemeal appeal problem? I mean, if the sentence is final, according to you, at the time restitution is just ordered without an amount, then how does the defendant have an ability to later appeal the amount of restitution that's ordered if it's not supported by the facts or, doesn't comply with the statute?
We've already resolved this. Judge Millett, when Hall and it's other cases, the whole group of, there was, I think, 3 of those cases came down. Judge Malone started handing out show causes why the case was ripe for appeal, because why the appeal wasn't premature. And we had to get things saying, okay, either you're going to do, and this is where I tried to mention to the court, and perhaps I should have clarified earlier, where district courts, I understand they're super busy, and I don't want to judge them for the way they run things. They do the best they can. But a lot of times restitution doesn't end up happening at all. It gets shuffled off, other cases come through, they do it. They deal with those. But that's the reality, and when Judge Malone was doing it, we would have to go, and again, I do lots of states appeals these days, so I don't see a lot of these. I assume it still happens, I don't know. But we would get a show cause on a premature notice of appeal. We would then have to get a journal entry saying whether or not there was going to be restitution or not, and then that premature notice of appeal under, I can't remember the case, moves forward, or an amended notice of appeal is filed based upon the subsequent restitution amount, if there was a restitution amount actually ordered. A lot of the time they'd say, no, there is no restitution amount. We get a journal entry saying that. But that's what happens. That's when sentence is final. And yeah, this court's dealt with that. I mean, maybe it's not happening as much. Again, I do mostly states appeals because I edit all the attorneys below me. So, but that's the reality of what happens. Sentence is not final until the amount of it. It's not, I ordered restitution, now everything's final. It's not final until the amount is determined. So either, and that's where we get to here is, either he was on probation or he wasn't. If he was on probation, then there's no restitution. If he wasn't, then he gets to start probation. It's really that simple. There is no way to split the baby and penalize him for everything, much as it may seem like he should be, but that's not the law. If there's no further questions, we would ask for the initial remedy of the restitution order to be vacated, but in the alternative, we would ask that the court reverse and order he be placed back on probation. Thank you.
Thank you, counsel. We will take the matter under advisement and issue an opinion as quickly as possible.